Hi, do you know what is the difference between the burden and degree of proof? In order for us to understand what is burden of proof, we will come to see one of the most popular dictum that was held in the case of Wilmington. It says that a person is presumed to be innocent until proven guilty. In a criminal case, the prosecution has the duty to prove the prisoner's guilt. The prosecution has the obligation to adduce sufficient evidence in support to his vital contention to prove the case before the court. When a party is bound to prove the existence of any fact, then it is said that he has the burden of proof. Next, there is three keywords that we need to understand. The first keyword is proved. A fact is said to be proven when the court believes that a particular fact exists. The second keyword is disprove. It was always used as the opposite of the term proved. It requires a positive act of adducing evidence, but it is for the sake of disprove the fact that has been established by the opposite party. The third keyword is not proof. A fact is said to be not proved when it is neither proved nor proved.
Okay, now I shall be explaining about the difference between legal burden and evidential burden. As you know, there is no definition for these two principles in the Evidence Act 1950. For legal burden, the main keyword we need to focus is that we need to reach the standard of proof which is required by the law. It also refers as positive law. It will be determined if the facts in issue has been established. Section 101 has explained about the bound to prove the existence of fact. Next, evidential burden. We need to produce evidence throughout the trial and then need to prove the main fact and tender sufficient evidence to be admissible in the court. Section 102 has stated that burden of proof lies on the person who would fail if there is no evidence. Next, as you can see here, these are the fundamental propositions in relation to the two principles. They we have four propositions.
In a criminal trial, the burden to establish the case will always remain with the prosecution. Once the legal burden is discharged by the prosecution, next, the onus will shift onto the defense to prove those circumstances to dislodge the assertion from the other party. So, who will bear the evidential burden is determined by the fact that which party will be most likely to fail in their submission about that particular issue if no further evidence were adopted. Thus, the legal burden is always stick on the shoulder of the prosecution, while the burden to introduce the evidence may shift in between of the parties.
Assalamualaikum and a very good day I bid to all of you. My name is Muhammad Ghazali. I'll be explaining about degree or standard of proof. Basically, standard of proof is known also as quantum of proof. Okay, I will be explaining regarding the example in this video after this. We will start with standard of proof. As we know, standard of proof is after we have considered who has the burden of proof, we have to consider what standard is required to discharge the burden. For example, in this person is accused of murder, and then the question is, what is standard of proof that we have to use? Sorry if my drawing is not that good.
Okay.
Moving on to standard of proof for criminal cases, the prosecution have to establish the beyond reasonable doubt and accused is balance of probability. And therefore, civil cases, prosecution have to establish beyond balance of probability, same with accused. Meaning that civil is balance of probability and criminal is beyond reasonable doubt. Okay, we take example for alibi in circumstantial evidence. Okay, take example, there is a house and then there is a thief breach into the house, and then there is another person A, going to the market during the time that the thief has broke into a house, and then the owner of the house accused the person A break into his house, whereas during that time the person A is going to the market. So person A have to prove he has the alibi by using virtue section 103 of Evidence Act.